Okay, I guess we start these proceedings. Good evening, everyone, and join me in welcoming my dear friend, Yvonne Dausab, Member of Parliament and Minister of Justice, for the Republic of Namibia. It is my pleasure to welcome you to this series that are run by the Chair of African Legal Studies at Bayreuth. My name is Togo Kaime. I'm the chairholder for African Legal Studies here at Bayreuth. I'm especially thankful that you have taken time from your busy schedule to be with us this evening. I know you were at Parliament just a couple moments ago, and you've dashed to your office to be with us. So this is much appreciated. I know that as an academic, which you still are, despite your role now, this is quite important for you, and we appreciate that. We get insights as a policymaker, but also to explore some of those issues around constitutionalism, particularly as they pertain to Namibia. So welcome to this series, and I will let my colleague Ligia Link to introduce you to our participants this evening.
Thank you very much.
Thank you. And I would also like to welcome everyone and briefly introduce our special guest today, Honor Yvonne Dausab. She's the current Minister of Justice in Namibian Cabinet since March 22, 2020. Furthermore, she is an admitted legal practitioner of the High Court of Namibia since 2000 and a notary public since 2015. She holds the LLB at the University of the Western Cape and the LLM with the special profession in human rights and African democratization at the University of Pretoria. Before her appointment to cabinet, she was the chairperson of Namibia's Law Reform and Development Commission from 2015 to 2020 and was previously the Deputy Dean of the Faculty of Law at the University of Namibia. And besides, she is passionate about law reform, teaching law, disability rights, social justice, and clinical education. She is well known for her oratory skills and is a regular feature on national television. For her impressive work in human rights, the Law Society of Namibia awarded her to the 2012 Human Rights Excellence Award, and moreover, she was the country winner for her work in education and training of the 2015 Africa's Most Influential Women in Business and Government. And yeah, today she will talk about using the law as a tool to enhance social justice, locating Namibia's value system using the text of the Namibian Constitution. Now I would like to hand over to you, Honor Yvonne Dausab. The screen is yours.
Thank you very much, ma'am, for Ms. Link, for that very elaborate and kind introduction. I appreciate the time, and I want to also take this opportunity, I may not get it later, to thank Togo for thinking about me and remembering that I would like to, at least even if it's partially, keep one foot of mine in academia. You know, you never know in the political space, you know, time here is limited and you need to just do what you need to do and then get out of the system. And then you need to find either your way back to your old home, which is for me, teaching and learning, of course. We were celebrating World International Teachers' Day, and I was reflecting in my own role of teaching. But in any case, I thought, you know, this is actually a topic I've been thinking about a lot, but I don't always think that one gets the opportunity to unpack it. It's very, very loaded, and I want to maybe just disclaim initially that there is a real possibility that I may not have covered the depth of everything that this important topic, at least in my view, covers. But I thought, let me provide some highlights and maybe a little bit of Namibian context of how do we see law play a role in enhancing social justice, maybe just some conceptions around what is the meaning of social justice, how do we understand it, how does it fit into our societies. Everybody uses that word, and many times quite loosely, but I think generally we understand social justice in a social context, a context of socioeconomic development, a context of sustainable development, and how all of that fits into the policy, institutional and legal framework within which we need to operate. So it is against that kind of thinking that I've prepared my presentations. I have a few slides, and because of the time limits, I want to get to them quite quickly. So one of the things I've tried to do is I try and frame the questions that will inform the discussion that I will have with the audience. So what are some of the key questions that I was asking myself as I was thinking about this? And I was thinking, why and how can we use the law as a tool? You know, because a tool is something that you use to facilitate or that you use as a catalyst. So I was thinking, what will be some of the key imperatives that I'll have to use to determine whether law can actually enhance social justice? And then I wanted us to also think about what are the value systems, particularly in the Namibian context, that informs or guides our decision making. What are the policies, laws, and jurisprudence that contributes towards social justice? What are the key imperatives? And for me, this is really the key of my presentation, is the key imperatives of law that will serve as catalyst to enhance social justice. And of course, I very vaguely look at the social justice paradigm in the Namibian context. What informs it, and what will we have to do to enhance it? So talk of something that I have learned very quickly as I was starting to get into the habit of presentations and speaking engagements, is that I always start with my conclusion. So I will conclude, or at least my conclusion is that social justice is a concept that is frequently used, and it is also considered a response mechanism to address social ills. It has been applied in any situation that affects our human existence. If people want to talk about unemployment, it's a matter of social justice. If they want to talk about access to justice, it's a matter of social justice. But I also conclude that we cannot talk about centrality of the rule of law and its adequacy if we don't talk about how it will enhance social justice. You cannot talk about law, you cannot talk about justice if you are not changing the lives of your people. You cannot talk about the centrality of the rule of law if the lives of our people remain the same. You cannot talk about a constitution if you cannot talk about how that constitution becomes alive and responsive to the needs of our people. So I want to, one of the other things and suppositions that I make is that perhaps we can think about the concept of transformative constitutionalism as a concept that is bringing hope to changing the lives of particularly vulnerable communities. So how we use our constitution is going to be very, very important in terms of enhancing social justice in any society. Namibia has, like many countries, including the African Union, has a vision, and this is our vision 2030, like I think many African jurisdictions have, is envisioning that Namibia will become a place where our people are developed, where we are prosperous, where we are healthy, confident, and we live in peace and political stability. And this vision really guides along with what we call national development plans. We are at number 5 now. We should run through 7 national development programs, and they are the guiding tools, if you want, of actualizing the vision that we have under 2030. And then, of course, under the current president, we have a Harambee Prosperity Plan, which also really speaks to some of his plans and thinking for Namibia during the time of his tenure. Now, the Harambee Prosperity Plan actually is linked to Vision 2030 and our development plans that are running up to 5 now. And then 2 more things that I'm concluding on is that we need to acknowledge that for us to build a cohesive society in a diverse nation, needs more than just promotion of socioeconomic rights, because it's not always easy to, and I quote, weave a very new tapestry from a diverse nation. So we need to understand that you cannot just promote socioeconomic rights. There is so much more that you need to think about, including what kind of laws what is your review and reform program in terms of your legal landscape? What is the policy thinking that government is driving? And also, what is the kind of support that you need to have as a society? So we can no longer just rely on government doing the work. We will have to think about how does the society participate in enhancing the kind of society that we want to see. And of course, something that is very clear and that I certainly buy into is the question about how do we survive? And survival in going forward as a society, and not just the Namibian society. I think any society, you need to constantly think about new ways of doing things, and also different ways of doing things. Coronavirus has taught us certainly that we can no longer just rely on the space of meeting in the physical space. We have to rely on caring for each other from a distance, and also being able to do a lot of things without necessarily seeing each other. Virtual activity has become the new normal. So as Namibia is moving towards a new normal, and I know many jurisdictions are, probably your own in Germany, is we need to think about what new ways of doing things should we introduce. And our Vision 2030, which I will briefly share with you now, shares that. So that is my conclusion. So if I run out of time, know that I have concluded.
Okay, dear Minister, there's no good point to intervene, but you are yet to share your screen. I know you're looking at this PowerPoint right now.
Yes.
But you haven't started it for the rest of us.
Okay.
Thank you.
Are you able to see it now?
Yes, perfect. Thank you.
Okay, very well. So I was concluding, but to start my presentation, I thought it would be nice to, maybe not in too much detail because it's on the screen, but just to look at what is Namibia's Vision 2030 look like, and what does it entail. And I just want to highlight that firstly, it is intended as a collective move in the same direction. And then then the second important thing that it does is that it conceives a new way of thinking and doing things. And what is that new way of thinking and doing things? Some of it is that we need to think about operating with an adaptive dynamic system or process that can continuously improve as opposed to a fixed plan, for instance. So we have 7 plans. We are at number 5 now that we are using to actualize the vision. Then secondly is that not only government is responsible for where we are taking our society. We are suggesting that it has to be the collective responsibility of all Namibians. And we talk about collective responsibility of all Namibians and you want to have a sustainable development or a developmental agenda, you need to think about what are the key kinds of partnerships that you need to have as a society. What kind of environment must government create for that society to operate, for society to function. So the society makes, particularly private sector society makes visions through investments, and you want to model a governance sector, you sharing with us transparent manner, do we know what government is doing when, and the development plans are intended to do exactly that. Then of course everyone is always focused on what is government's policy on this particular question, what is the laws on this issue, and so forth. And I've always said law is not enough. As a lawyer myself, I know that law often responds to issues after the fact. It's always, the interventions are ex post facto in many instances. But of course, law also can drive a particular agenda or a narrative that the government and the society it leads wants to see. So it's important for us to understand that we must focus on the impact that our laws have, the impact that our policies have, the impact that our institutions have in driving an agenda that is responsive to the needs of our people. And of course, lastly, maybe on this particular slide is there's been a lot of criticism, not only in Namibia, but elsewhere, about the silo mentality that many of our people have, and many of our governance models are predicated on. We need to think about moving away from sectoral approach to governance. For example, I'm thinking about, as a Minister of Justice, there's so many other ministries that we interact with, for example, and the question should be, not only do we drive the agenda from a legal perspective, but also how can we integrate what other ministries, offices and agencies are doing in moving whatever program we have around enhancing and bettering the lives of our people. So you cannot, for example, you can talk about accessibility of courts, but if your court system is not functional, people will not be able to bring matters to court and resolve the disputes that they have at whatever level that it takes place. A dispute that could be in the home, how do you resolve for example, a huge problem of domestic violence and gender-based violence we have in the country, if we take a sectoral approach to it. So there has to be a interchange and intersection between various disciplines, but also various sectors, because there is law is one part of it, but there is a very serious exchange. I know that Professor Viljoen had written a very good book, Beyond the Law, and talking through the various tensions and commonalities and similarities between law and other social disciplines. So it's important for us to understand that there has to be an integrated plan that works in resolving the issues. The final issue that I want to highlight is the impact of stereotypes on how societies as a collective move forward. I say this because, remember, Namibia, just like South Africa and to some extent also the United States, and I'm sure Germany has some experiences, historical experiences that are not entirely comfortable, but also not entirely palatable. And what that does is that it does create certain tensions, ethnic tensions, race tensions, color tensions. And so stereotyping has always led to people excluding others, because they believe certain things about themselves. And so our vision tries to also address that concern, to say we need to stay away from anything that is likely to polarize the society, because once the society is polarized, it is clear that the society cannot reach the vision that it wants to reach at some point. So what does the Namibian vision want? The vision is that we have a population that is healthy, that is well educated, skilled, proactive, financially stable, with a broad range of talents, people that have positive attitudes towards themselves, fellow citizens, their country, and the global humanity, but also a country we want to be that will become a good choice for investment in an atmosphere of peace, security, and political stability, which I believe Namibia still embodies at the moment. So that's our vision. So what is social justice then as a concept, but also in practice? What does it mean for me personally, but also what does it mean for the Namibian society, at least from what I understand them to mean? And so I want to apply it loosely so that we avoid the overemphasis on theory rather than on the practical application of the concept. But the concept, in my understanding, is laced with key value propositions. And those value propositions are equity, equality of outcome, achieving fairness, treatment that recognizes dignity, equal worth, and encouraging self-esteem for all. And of course, the famous access to justice. So those are the key value propositions that, in my opinion, define social justice. Then, of course, public participation is important, not only in the Namibian context, under our Article 1, Sub 2 of the Constitution. Actually, the legislature is the representative authority of the Namibian people. So we want to ensure that if you are representing, that you ensure that there is continuous public participation. And how that happens is, for example, through our lawmaking process, we ensure that you don't get your whatever proposal or review you have without some kind of public involvement, public views to be shared at those platforms. That's important. So why do you need, why the conception of social justice, and what should it look like in practice? There should be a sense, and maybe not just a sense, because it may be a misnomer if I say sense, but there should be a reduction of inequalities in the Namibian context, and there should be a fair redistribution of wealth and income in terms of our concept. So that's just the short version of what I think social justice represents. Then what are our key challenges in Namibia from a social developmental perspective, and that should inform the agenda for social justice? At the moment, we have challenges around unemployment, high levels of income inequality, which is a clear remnant of apartheid. We have challenges around universal health coverage, access to affordable land and housing, that's a key one. Incorporation and increased visibility of disability rights, gender equality, and in recent weeks we've seen a massive increase in sexual violence and gender-based violence. So that is the social agenda, I think. If you're talking about social justice, what should your policy respond to? What should your laws respond to? What should your institutional setup respond to? These are the key ones. Of course, there are others, but I think these are the key ones that Namibia is battling with at the moment. And I'm sure many other jurisdictions would have similar problems that they're struggling with. So for us, at least from the point of view of using the Constitution as a tool of transformation, and using the law as a tool to enhance social justice, you need to think about what is your value system as a society? What are the things that makes Namibians tick? Do Namibians understand when we talk about values and principles of our society, what does that look like? And where does it come from? And so I thought I should just share some key ones that we've really derived from our earlier jurisprudence in the constitutional court system. And so the first one for me is, what is our approach to constitutional interpretation? That's important. It shouldn't be mechanic. Right back in 1991, with the allegation of who killed Anton Lubowski in S versus Atchison, the court already said we should not, our approach to constitutional interpretation must not be the same as interpreting a normal statute. It must be purposive, it must not be mechanic, so that you can avoid what he, at that time, the late Justice Muhammad, may his soul continue to rest in peace, referred to as avoiding the austerity of tabulated legalism. So that's important. Constitutional interpretation is not enough to enhance socioeconomic justice, but it certainly helps with how society responds to a judgment that comes from our courts. So the courts must know that they cannot just be entirely legalistic in the way they interpret constitutional challenges and interpretation of our constitutional provisions. And of course, if you are talking about a society that is caring, a society that needs to have a redistributive character, you must have it in the text of your constitution. And I must say the Namibian Constitution, in a number of the provisions, it has been described by scholars as a caring and redistributive in character, and also supportive of a futuristic society. The Constitution in its text must also be very clear about breaking from the past. The Namibian Constitution in its preamble, but also in other provisions, most notably Article 23, which focuses on apartheid and affirmative action, was clear about wanting to break with the past. You will also see in other provisions that deals with the role of the legislative authority and of cabinet, it also talks about we should never find ourselves going back to anything that resembles apartheid. So it's clear the Constitution expresses a break from the past. And of course, those of us as scholars who are familiar with the concept of Ubuntu would know that the concept of Ubuntu, a South African conception of traditional values, has been firmly edged in the South African jurisprudence, particularly the South African constitutional jurisprudence. So I've also been thinking quite a bit lately, particularly with all the gender-based violence that's been happening in the country, and the sexual violence, particularly against our children and children with disabilities. I've been thinking a lot about family values and what is the Namibian traditional value that responds to these kinds of issues, for example. So at the moment, the Namibian traditional values are undefined, but they are known. And I think because they are similar in character and practice with Ubuntu, it will be useful for us to know that is an indigenous value system that we should encourage as Namibians, and we should think about it. We should think about some of the challenges that we're facing in our local languages, and we need to think about how our customary practices are responding, for example, to issues of gender-based violence. How do we define, for example, the equivalent of Ubuntu in Kwekwe in Namibia, for example, or in Oshiwambo in Namibia, or Oshiherero. So all of the languages that we have, how do they respond? What is their description in the local language of sexual violence, of rape, and protection of our children, of our women? What is the place of our family value system, and so forth. So that's the kind of thinking on that particular point. And of course, our value system is anchored around a separation of powers, your independent judiciary. In 2015, we had a Judiciary Act because we wanted to reaffirm the independence and the integrity of the judiciary. And then, of course, the legislative authority of Parliament. We have a bicameral Parliament, National Assembly and the National Council. We wanted to ensure, and then, of course, executive must ensure that the policy frame that guides its decisions is based on the needs of our people. And then finally, we have case law, our jurisprudence that has reaffirmed that if you want a society where social justice will be the anchor, or rather, if social justice is what we are all striving for, if the kind of vision that Vision 2030 has in mind for us, then we need to think about what are our contemporary norms and aspirations and expectations and sensitivities as Namibians. How do we see, and I talk about gender-based violence because it's been very, very prominent and profound recently. And so our case law has been reaffirming what is it that we need to look at when we talk about our value system. So that's what anchors us. Well, that's what we should be going to when we think about enhancing social justice, but also think about how do we use the law to do that. I know that I'm running low on time, so I'm going to rush through the last portion of my presentation, which is really to look at what are those key imperatives of using the law as a tool. And I was really thinking about somebody who's in a garage with a toolbox, and in that toolbox is something called the law. And I was thinking practically, what would that mean? So if you want to use the law as a tool, you need to know that your constitutional text is supporting those imperatives that you want to see if you're going to enhance social justice. And so the constitutional text is important. What does your preamble say? What does your Bill of Rights provide? Life, dignity, non-discrimination, the freedoms. Unlike in South Africa, for example, and I don't know what the situation is in Germany, but certainly Namibia does not have a very elaborate provision on socioeconomic rights in the Bill of Rights. The right to education is the only one. So the rest of it is couched in principles of state policy, and this is really where the socioeconomic framework is provided for if you want to enhance the welfare of your state. Scholars, and I agree with them, call this part of our constitution as the caring character of our Namibian constitution. Of course, there's something on the mixed economy, and that provision wants to take care, obviously, of the capitalist, free, economy type of language combined with your socialist tenets. And the intention really is to ensure that we secure economic growth, that there is prosperity in a life of human dignity for the Namibian people. Then, of course, under Article 144 of the Namibian Constitution, we import domestic law, and we've always argued that, in the event that our domestic text does not support, for example, a particular right, or is not supportive of a particular socioeconomic condition. For example, we don't have a right to housing in our Bill of Rights. For instance, can Namibians use the Namibian Constitution with reference to Article 144 to import international law that we have ratified, and we've ratified the key human rights instruments, most of the African instruments, including the African Charter on Human and People's Rights, the Maputo Protocol, all of the key provisions, the Children's Protocol as well, or Convention, or Charter rather. So we have ratified and acceded to most of the key international instruments so that we could enhance the safeguards that those instruments provide, and that Namibians could could lean on to those using Article 144. So the question really, and I will not answer it now, maybe it will come out when we do question time, is the text sufficient to create a socially just society? I think it is, but some scholars may not necessarily agree with me. And then, of course, the second one, apart from the Constitution, is statutory text. So we must ensure, we must guard against legislation that's unconstitutional, and we must ensure that the key principles of legality are, our laws are, consistent with those key principles. I will not go into them. I think everybody is familiar with them if you're a law graduate or if you're a legal scholar. The other is imperative that I'm suggesting is public interest litigation. And I think under public interest litigation, we need to think about availability of legal aid or free legal assistance to indigent clients, the equivalent of the legal assistance center in Namibia. I know there are many legal centers in other African countries. Accessibility and affordability of legal services. And I think it's a challenge. And here I'm not only talking about access to legal representation, which is provided for under Article 12 of the Namibian Constitution. Here I'm also talking about other legal services that people would be that would want access to. For example, access to maintenance payments. For example, access to a domestic violence court where you can have protection order, for instance, what is, access to gender-based violence protection units after hours when you really need it, or similar institutions that can help, women and children and men that may need that service at that particular time. And of course, what is the impact of cases that are taken to court, for instance? What kind of impact does it have on our society? Is it likely to change the law? For instance, if we take that matter to court, how many people does it affect? Is it just an individual, or is it, does it affect a larger segment of our population? What does our funding for civil society organizations that undertake strategic litigation look like? For example, Namibia has been declared a middle-income country, and as a result, a lot of the development partners have withdrawn from Namibia because, we are considered a relatively rich country, and so that has affected a lot of the civil society organizations that may be working in that area. And of course, it will be important, particularly with lawyers, that they infuse a human rights constitutional language in court papers, something that we don't see a lot. So often courts have to rely on other jurisdictions, particularly South Africa, Canada, India, which have been very popular with our courts, and to a limited extent also Zimbabwe, where we would look at what have other courts said, and that would have persuasive value on the decision that the court has to make. So it will be important for us to use that as part of our court papers and so forth. Then it's important that there is a jurisprudence developed. The development of jurisprudence is important. So it's not just about the profile of cases that are coming to court, but it's also about what is the outcome of that case. What are our justices? Are they activists? Are they willing to stretch a little bit? We had a judgment in the Supreme Court, which is the apex court in Namibia, and their decisions are final and binding, where in Fisher versus the Minister of Finance, the court had the opportunity, for example, to define equality with reference to disability rights, and the court missed that opportunity. So it's what kind of cases are coming out of our courts is going to be very, very important, and of course they will be guided by what are the norms in Namibia, and of course, and then are those cases responsive to the needs of our people? If we are taking a matter, when there's been a lot of challenges even around housing and people being evicted because they are taking the law into their own hands, and what should be the court's attitude or disposition towards those kinds of cases. And then, of course, how accessible are courts. And accessibility means availability of competent presiding officers, availability of legal representation, legal aid, how accessible are courts. And I think generally, I think our courts are reasonably accessible, but of course we have human resource challenges that we need to address. So as I'm concluding, and really I'm concluding, and I'm happy that I had started with my conclusion, is that, so what are the things that will enhance social justice in Namibia, and I believe also elsewhere? Certainly responsive policies, laws, and institutions. Implementation has been our biggest challenges. So we may have very, very beautiful laws. We may have acceded to all the international instruments, all the good ones, but if our implementation rate is low, then it would means hollow. Respect for laws is key. So we need to take some practical steps to actualize the laws, but also to ensure that the institutions that are implementing these laws are effective. We need to think about availability of resources here. It's not just financially, it's also infrastructure, it's human capital, it's time, and it's also evaluation of progress that we need to think about. How responsive is our legal profession? Our profession needs to think about not only money, but also we need to increase the pro bono culture of our legal profession, the independent one. We need to reconsider the fee structure, because that's what's keeping our people from not only accessing justice, but using the law to fight the battles that they have. If somebody is dispossessed by a corporate or a bank, they don't have access to legal representation, so they lose a house. Do we have a functional justice system? Yes, I think in Namibia it certainly does. But a justice system is about accessibility of courts, it's about availability and affordability of legal services, and it's also access to legal aid, for example, and legal representation. So it's a number of things that anchors a functional justice system, including independent judiciary that has integrity, and that is also competent. So it's important that we understand the functional justice system within that paradigm. And of course, now with coronavirus, we understand that there's need for us to think about our governance models, our justice models, from a digital perspective. So I have concluded right at the beginning, so that brings me to the end of my presentations, Togo. Thank you very much.